In this video, I will explain how Florida recently became one of the most non-compete friendly states in America and how it impacts your business. I'm Santiago Cueto, board certified international business law expert and best-selling author. Something remarkable happened in Florida earlier this year. While most of America was moving to ban non-compete agreements, Florida went the complete opposite direction. The state passed a law so employer-friendly that it flipped decades of employment law on its head. This isn't just a small change. This is a seismic shift that affects hundreds of thousands of workers and businesses across the Sunshine State. The law is called the Choice Act. That stands for Contracts Honoring Opportunity, Investment, Confidentiality, and Economic Growth. And it became effective just a few months ago. Here's what makes this so significant. For the past several years, the national trend has been moving away from non-compete agreements. California has banned them almost entirely. Minnesota banned them. Wyoming banned them. And the Federal Trade Commission tried to ban them nationwide. But Florida said no. Florida decided to go in the exact opposite direction. Under the old Florida law, non-compete agreements could last a maximum of 2 years. Courts had to analyze whether they were reasonable. Employers had to prove they had a legitimate business interest. They had to show the agreement was necessary to protect that interest. The burden of proof was on the employer. The new law changes everything. Non-compete agreements can now last up to 4 years. That's double the previous maximum. But here's the real game changer. The law creates a presumption that these agreements are in fact enforceable, not the other way around. That means that the burden of proof shifts. Now the employee has to prove they won't compete. The employee has to use clear and convincing evidence. That's one of the highest standards in civil law. The law doesn't apply to everyone. It covers what it calls covered employees. These are people who earn more than twice the annual mean wage in their county. The exact number varies by county. In some Florida counties, that threshold is around $80,000. In others, it could be as high as $150,000. This typically includes tech workers, it includes financial professionals, and it covers marketing executives. Sales directors also fall under this category. So do many managers and skilled professionals. If you're a high earner in Florida, this probably affects you. The law introduces something new to Florida called garden leave. This is a European concept that hasn't been common in American employment law. All right, here's how it works. An employee gives advanced notice before leaving. During that notice period, the employer keeps paying their full salary and benefits, but the employee doesn't have to work. They can literally go tend their garden. That's where the name comes from. Under Florida's new law, garden leave can last up to 4 years. The employee gets paid for the first 90 days no matter what. And after 90 days, they can stop working but still get paid. Or they can work somewhere else if the employer gives them written permission. The catch is this. If you try to work for a competitor without permission, the employer can get a court order to stop you from doing that immediately. All right, if you're finding this information valuable, do me a favor and hit that like button right now and subscribe to this channel. I break down complex business law topics every week. You'll want to stay updated on changes that affect your business and your career. Now, for Florida businesses, this law is a gift. They can now protect their confidential information better than ever before. They can protect their customer relationships. They can prevent key employees from immediately jumping to competitors. They can enforce non-competes globally. There's no geographic limitation anymore. An employee in Miami can be prevented from working for a competitor in California or even overseas. The law also gives businesses powerful enforcement tools. Courts must issue preliminary injunctions unless the employee can prove no competition will occur. The employee bears that burden, not the employer. And if the employer wins, they get attorney's fees. They get costs. They can recover all monetary damages. For employees, this law creates serious concerns. You could be locked out of your industry for 4 years. That's an eternity in fast-moving fields like technology or finance. You could be forced to take a lower-paying job in a different field. And you could face expensive litigation just to exercise your right to work. Here's what's particularly concerning. The law doesn't clearly require employers to pay you during a non-compete period. Garden leave requires payment. but a straight non-compete might not. You could be both unemployed and unable to work in your profession. Even if your employer fires you, you might still be bound by the non-compete. The law is silent on that issue. Now, this law makes Florida an outlier. Most states are moving towards limiting or even banning non-competes. The Federal Trade Commission tried to ban them nationwide. Federal courts blocked that rule. Now, the FTC eventually withdrew its appeals, so the federal ban is now dead. But most states still aren't making non-competes easier to enforce. They're making them harder. Florida is betting that strong non-compete enforcement will attract businesses. The theory is simple. If you're a company with valuable trade secrets or important customer relationships, Florida offers you better protection than almost anywhere else in America. That could drive business investment. It could drive job creation, but it could also trap talented workers and slow innovation. So if you're a Florida business owner, you need to review your employment agreements right now. Make sure they comply with the new law. There are specific notice requirements. You must tell employees they have the right to consult a lawyer. You must give them at least 7 days to review the agreement. You need written acknowledgement that they'll receive confidential information or customer relationships. If you're an employee, read any non-compete or garden leave agreement very carefully before signing. And consider consulting an attorney. Understand what you're agreeing to. These agreements can affect your career for years. Don't sign something you don't fully understand. Florida has made a bold choice. While the rest of America debates whether to ban non-competes, Florida doubled down on them. This law will shape employment relationships in Florida for years to come. Whether it helps or hurts the state's economy remains to be seen. What's certain is this: if you work in Florida or do business in Florida, you need to understand these changes. If you found this video helpful, give it a thumbs up and subscribe to my channel for more business law insights. I'm Santiago Cueto, your Florida business attorney. Be sure to stay and watch more of my videos right here.